Hello, my name is Paul Hutchinson and I'm the founder and director of a law firm based here in the southwest of England. My practicing career stretches over 20 years. I was a private practice solicitor with a firm in Bristol before being made redundant around about 18 years ago, which is when I founded the firm that I run now. And my role in life is to provide advice to clients on the subject of asset protection and tax planning, to try and protect as many of those assets that we've worked all our lives to get from all the nasty third-party attacks, and also to reduce the amount of tax that we pay not only during our lifetimes but when we pass away. I'm STEP qualified, having sat and passed the Advanced Certificate in Will Preparation, and I was also published in the 2017 Legal Parliamentary Review. Now, I'm not always just based here in the Southwest. I work with a strategic network of very, very trusted partners who can provide these services all throughout the United Kingdom. So wherever you are based, we can help you with asset protection and tax planning. So just what do I mean by estate planning? Now, you may have consulted your lawyer, wondering what estate planning is all about because it's a buzzword, it's something that is often spoke about today. What I like to describe as estate planning, we can divide into two main sections. We can look at asset protection and we can look at tax planning. Now, within those two subheadings, what we can look at again is a further division between lifetime and death planning. So something that we've all probably heard of are wills. Wills are documents that we look at putting in place to set out where we want our assets to go when we pass away. But we haven't always heard of things like lasting powers of attorney. Now, lasting powers of attorney are documents that we put in place to make sure that when we lose capacity, we lose that ability to make decisions for ourselves, that the people that we choose make those decisions on our behalf, rather than leaving it to the court of protection for someone that you don't know to come in and start making those decisions on your behalf. We can then think about trusts. What are trusts? I shall go into those in a bit more depth a little later on. But trusts have been around for about 3,000 years. These are not a new product. Okay? Trusts will provide asset protection and in some cases tax planning opportunities to protect those assets such as your main home, your rental property, your investments, your cash, your savings. So estate planning can provide an opportunity for all of us to put documents in place and planning in place to maximise what we can pass on to the next generation free of tax or paying as little tax as possible and in as protected an environment as possible. So let's have a little think about wills. How many of you have heard of wills? How many of you have browsed wills, whether it's on the shelves at WH Smith or you've actually been to your lawyer to discuss the importance and benefit of putting a will in place? Now, one of the most underrated benefits of having a will is guardianship for your children. Just think about it. If you pass away and you've got any children under the age of 18, what would happen to them? Most people think that if there are grandparents alive or you've got brothers and sisters alive or even older children, that your minor children will be cared for by those individuals. But that's simply not the case. In most situations, if you have minor children, then there will be a court hearing to decide who is best placed to care for them. And whilst that court hearing is taking place, your child will be in care. Now, there's a huge debate about whether the foster care system and the social care system is adequate and fit for purpose. But what I can assure you is that if you know who you would like to look after your children when you pass away, you would much prefer to make that decision than leave it in the hands of the courts. And it's a will with a statement of guardianship where you can put those wishes into operation. So for people that say, gosh, I don't need a will because I've only got a few £1,000s in the bank and I rent my property, especially true with younger couples, they've got a toddler. Putting that guardianship clause in a will is extremely important. And if you do a will for no other reason, that's something that you should really give serious consideration to. The other myth is that when you have a married couple, for example, they say, it's okay, everything will just go to my wife. If I pass away, there's nothing to worry about. I don't need a will. Well, again, that's simply not true. Depending on the value of your estate, there is what we call the statutory legacy, a fixed sum of money that will pass to your spouse when you pass away. And if you have children, then that statutory legacy will be reduced and some of your estate will go to your children rather than to your spouse. Now just think what confusion that may cause if they're your children and not your spouse's children. So having a will in place will ensure that the people that you want to look after your estate when you've passed away, commonly known as your executors, and to care for your children, what we call guardians, is actually what is going to happen, rather than leaving it to what we call the intestacy lottery. Some people say, well, surely I can just put a £10 DIY will kit from my local retailer. Now, there is an argument to say that having that is better than nothing at all. But having that professional advice on the structure and the tax efficiency of your wills and whether the people you want to appoint are the right people is something that you should give serious consideration to, rather than just filling in the blanks on a generic sheet of paper. So what is an LPA, a lasting power of attorney? Now, an LPA is something relatively new in estate planning. LPAs have only been around since 2007. Prior to that, they were called EPAs, or enduring powers of attorney. Now, whilst wills deal with what happened when we pass away, a lasting power of attorney is a document where you can appoint the personal persons of your choice to make decisions about your property and your financial affairs and your health and welfare when you no longer have the mental capacity to do so. Now, just some common examples of this could be that you've had a stroke, that you've had a fall at work, you've banged your head, you've had a car accident, you're in a coma. Even obviously with the recent COVID pandemic, people were in hospital in comas, unable to make those decisions. Now, if you don't have a lasting power of attorney in place, appointing your spouse, your children, your brother, your friend to make those decisions on your behalf, someone that you care about, a loved one, will have to apply to the Court of Protection for a deputyship order. Now, the problem with the Court of Protection is that the application fees are incredibly expensive. At the moment, they're just shy of £400 for an application for a deputyship order. The other issue is the time. Unless the application is urgent, basic applications could take between 6 and 9 months to be heard by the court. And even then, your application may not be granted. Add to that the additional legal fees involved with the huge ream of forms that you need to fill in for a deputyship application. It is far, far less cost effective than having a lasting power of attorney document in place. Now, one of the most common mistakes with lasting powers of attorney is a hangover from the old enduring power of attorney system, and that is that they're just left on the side in their unregistered format. Now, at the moment, registration takes between 3 to 4 months. At the height of the COVID pandemic, this was 6 to 7 months. Now, during that time, your attorneys cannot make those decisions on your behalf. Now, with the old system, you couldn't register your power of attorney until you'd lost capacity. But with the new lasting powers of attorney, they can be registered, put in the drawer, and brought out at a moment's notice when the unforeseen happens. So as well as looking after your wishes when you pass away, please make sure that you've got your documentation in place for when you're alive, but you'll no longer have the capacity to make those decisions yourself. Now let's have a little think about something more in depth with regards to will planning. Many people have heard of property protection trusts, or PPTs. Now, just what is a PPT? A PPT is a trust within the will. Now, what do I mean by a trust? Trusts are a myth. Trusts cause distress, concern, that they're for the super rich, that they're very complicated. Now, a trust is quite simply an arrangement between 3 sets of individuals. The person who establishes the trust, which is sometimes called the settlor, or in the case of a will, the testator. The trustees, who manage the trust on behalf of the person who sets the trust up, and then the beneficiaries. So in the most simple form, a trust is a very, very basic arrangement. Yes, of course, they can be used for people to make huge tax savings, but this isn't something with which we get involved. Now, a trust within a will is there to provide protection. When we structure wills, we can have what we call outright or absolute gifts. And that is when the person who makes the will passes away, the inheritance, the gift, the legacy, whatever it is they are leaving, drops straight into the lap of the recipient. Now, of course, this may not be beneficial to the recipient. Just imagine if they were going through a divorce, through bankruptcy, they were living abroad. Something unfavourable which would mean that inheriting at that particular moment could not be very beneficial for them. So a trust is there to provide a layer of protection around that inheritance. It allows the trustees to negotiate with the beneficiaries to decide when is the best moment for them to inherit, when the divorce has passed, when the bankruptcy is over. If they're living abroad, when they've had time to take legal, tax and financial advice both in the UK and in the country in which they live to ensure that their inheritance isn't stung under local tax laws. Now, specifically, a property protection trust covers, as it may sound, the property, usually the family home. Now, in a common scenario, the husband and the wife own a property jointly, whether it's as beneficial joint tenants or tenants in common. Now, if the husband was to pass away and to leave the house outright to his spouse, imagine two very, very common potential scenarios. As a younger couple, imagine if that spouse got remarried. Imagine if that spouse got remarried to someone and had children of her own with the future spouse. When that husband passed away, he left his share of the house to his wife with the full intention that perhaps it would go to his children, to his brothers and sisters, or even their children. But the remarriage has caused what we term sideways disinheritance. His share of the property has gone to his wife, and this could be diluted down her new partner's bloodline. Second situation for an older couple. Imagine the husband passes away and leaves his house to his spouse. Imagine she ends up in residential care. Residential care on average could be £50,000 to £60,000 a year, and it wouldn't be long before that family home is means assessed. And as we shall discuss later, whilst the family home is not necessarily going to be sold, a charge could be put on the property sold, and the proceeds used to discharge that liability after death. Imagine if the husband had set up a property protection trust in his will, leaving his share of the house in trust for the benefit of his spouse. She could live there, she could downsize, she could upsize, she could do whatever she needed to do. But crucially, the whole house doesn't become her asset. If she then ends up in a care home later on in life, the local authority are only able to assess the value of half the property, meaning that the husband's share, when he passed away, is locked away and protected for the benefit of his children or his chosen beneficiaries. And in the case of the remarriage, imagine if the husband, rather than leaving the property to his wife, had left it for the benefit of a property protection trust. If she remarried and gave her share of the property to her new husband, to their children, to her sisters, to whoever she gave it to, the share of the property that was held in trust by the husband when he passed away is guaranteed to go to his chosen beneficiaries. So with a little bit of thought, a little bit of structural change, it is perfectly possible for the first spouse to die to protect their half of the house from any unforeseen third-party attack, whether it be the local authority, future taxes, foreign tax systems, divorce, bankruptcy, or even long-term care. The Property Protection Trust does have one limitation, however, and that is that because it's part of a will trust, it only comes into operation when you've passed away. Therefore, at best, in the case of something like long-term care, it can only protect half of the house. Now, if you want to protect all of the house, this is where the Lifetime Family Asset Protection Trust comes in. Now, lifetime trusts and trusts in general are something of an enigma. People don't like talking about them, and often there is, ironically, a distrust of trusts because they're not in common parlance. But in fact, trusts have been around for approximately 3,000 years. The first known mention of trusts being by Homer in his Iliad. Now, modern trusts were developed around the days of the Crusades, with the Romans having brought the concept of the will trusts to these shores when they invaded. So for anyone who thinks that trusts are a modern idea, look back in history and realise that they have been around in their current form without many changes for a long, long time. Now, put simply, a lifetime trust is a trust that you set up when you're alive. You don't wait until the will kicks in after death for that protection to be put in place. Now, if we take an example of a couple, imagine a husband and a wife. Imagine they put property protection trusts in their wills, but imagine they both end up in care. How much protection is there for them? The answer is none at all, because they're both alive. Their PPTs in their will have not yet kicked in. Now, if this is of concern, what should they do? They should take that idea of setting up a trust and putting their respective shares of the property into trust and do it now. Do it during their lifetime. Now, if both of them end up requiring care, the property is already in trust. We don't have to wait until they've passed away for that protection to be effective. Now, one of the things that concerns people about putting their properties into trust is this notion of deliberate deprivation. Are we allowed to put our houses in trust and other assets to avoid long-term care fees? And the answer is we are. The legislation, the Care Act of 2014, is very, very clear. We can do what we like to protect our assets, to minimise the tax that falls due when we pass away, providing that it is done at a time when the need for care is not reasonably foreseeable. That means acting soon whilst you are mentally and physically as fit as possible. Now, the penalty for deliberate deprivation is not something to be afraid of. I had a client once who was concerned that they were going to be dragged into the local market square, put in the stocks and pelted with rancid vegetables. And that's simply not the case. Deliberate deprivation just means that the property will be taken and sold to pay for those care fees, which, if you think about it, is exactly what would happen if you'd done nothing at all. Nothing ventured, nothing gained, nothing lost. All that you've lost, if you want to look at it like that, is the cost of having established the trust in the first place, which in most cases is just the equivalent of a week or two's worth of care fees. Because care fees varies across the country. Clients who live in London and maybe in Surrey could be facing care fees of over £100,000 per person per year. Whereas in rural Gloucestershire, for example, it could be as low as £40,000 to £50,000 per year. But that's still a lot of money to be paying, and most people do not have that disposable income to pay for those care fees. When that income runs out, the local authority traditionally would have forced the property to be sold by getting a court order, and they would have used the money to subsequently pay for those care fees. But the local authorities are a little bit more clued up now than they used to be. And what they will do now is offer what they call a deferred payment arrangement. And that is a charge over your property which must be repaid when you pass away. Now, the problem with a deferred payment arrangement is there's interest. And nowadays, interest will run not from the date of death until the date the debt is repaid, but it will run from the date that you required care. Now, usually the interest rate is something between 7 and 10%, meaning that your family, when you've passed away, will have to get the property sold in order to refund the local authority. Now, there lies a big problem. You can't sell a property until you've got a grant of probate. You can't get a grant of probate until inheritance tax is paid. And you can't pay the inheritance tax sometimes until you've sold the property. You've got a perpetual loop. Now, if the property is in a family asset protection trust, the trust can be structured in such a way so that the property can be sold without the need to obtain a grant of probate, meaning that those funds are flexible, hopefully not to have to pay too many debts that you leave behind, but that they can be there to provide those legacies for the grandchildren, for your children, for your family, without what is at the moment maybe a 6 to 9 month wait for a grant of probate. So the Family Asset Protection Trust is not something to fear. It's not something for the super rich. It's not something that's complicated. If you're trustees of your own trusts, you don't lose control over your home. You're not giving up the decision-making process about when you move and where you move to somebody else. What it is an effective asset protection trust tool, which will leave you in no worse a position than if you'd done nothing at all. Everything to gain and nothing to lose. Something I'm often asked is when this loophole is going to be closed. Now, what we have to remember is that those who pass the legislation, those who sit in the House of Lords, as was the Supreme Court now, always have in the back of their minds the thought that they don't want to be undoing any planning that they've done themselves. Tax statutes, trust statutes, if they are changed, are not retrospective in their action. So anyone who has got a trust in place can pretty much guarantee that the law, if it does change in the future, will not affect the planning that they have put in place. We have to remember that the Family Asset Protection Trust is not an inheritance tax planning tool. Inheritance tax planning with the family home is notoriously difficult due to complicated rules about being able to live in your property rent-free, so that's not what we're trying to do. But the trust is structured in such a way as to make use of all the current inheritance tax exemptions and allowances. For example, the residential nil rate band and the transferable residential nil rate band. But if inheritance tax planning with trusts is something that you're interested in, then we do have the Settler Excluded Asset Protection Trust. This is a trust not for the family home, but for other assets, which if you put them into trust more than 7 years before you pass away, the value of those assets will be outside of your estate for inheritance tax purposes. And this can all be done without triggering charges to capital gains tax, thanks to various exemptions and reliefs. And if this is something you are interested in, please do ask and we'd be more than happy to talk to you about it. So we have what I term the triangle of estate planning. We have wills, we have lasting powers of attorney, and we have lifetime family asset protection trusts. Wills appoint the persons that you choose to look after both your children and your assets to ensure that they pass to your chosen beneficiaries as quickly and as smoothly as possible when you pass away. We have lasting powers of attorney, which are documents that appoint the people that you choose to make decisions about your property and financial affairs and your health and your welfare when you're no longer mentally able to do so. And then we have lifetime family asset protection trusts, which protect your assets against third-party attack from divorce, from bankruptcy, from foreign taxes, and potentially from future care fees. Now, I wish I was able to cover the whole of the United Kingdom, but unfortunately, I'm not. So I work with a network of trusted associates, strategic partners, who will be able to provide you with bespoke advice about some, all, or other aspects of estate planning that we haven't necessarily covered today. So give them a ring. Find out what they can do to help you. Now, you may choose to put all of these things in place or none of them, but at least have the conversation to understand the consequences of the decisions that you're making. You can go in fully informed to make sure that your family's future is as protected as it can be.